and welcome to this Midis-conférences de Jeunes Chercheurs organized by the Centre de Recherche en Droit Public. This presentation, which I have the privilege to introduce, is given by Dimitri Patrinos. Dimitri is a lawyer and is currently pursuing his Master of Laws degree at McGill University's Faculty of Law, where he's also a graduate fellow of the McGill Research Group on Health and Law. He's a graduate of the Civil Law, LLB, and Common Law JD programs at the Université de Montréal. He's also the holder of a BSc in biology from Concordia University and was called to the Ontario Bar in 2020. He is a jurist member of the McGill University Health Center's Research Ethics Board. This presentation on telepsychiatry and mental health equity in correctional facilities gives, I think, a striking and important portrait of some of the legal challenges and opportunities surrounding access to mental health services in one of Canada's most underserved populations, those who are incarcerated in federal and provincial institutions across the country. Dimitri, I think, does a great job of summarizing these issues and in charting a potential path forward. The use of telepsychiatry is increasing in importance and in volume in a variety of different settings, and the correctional setting is one that we have to date probably not explored as well as we should. So I think this is an important presentation, and I'm very, very happy to be able to introduce it. So thank you and enjoy.
Good. So given that health equity is a longstanding important issue and one that has received a lot of attention over the last couple of years, today I would like to examine the implementation of a specific type of telehealth called telepsychiatry to a specific population for whom access to health and health equity has been a longstanding issue, that being incarcerated individuals. So today I will discuss how telepsychiatry can be a vector for mental health equity in correctional facilities and what legal opportunities and legal challenges may arise from this. So telehealth more generally is a field that is constantly evolving and continually growing. So there is no one standard definition for it. And often you'll see that the term is used interchangeably with telemedicine, though some argue that telehealth is a more global concept than telemedicine. But the World Health Organization has identified 4 key components of telehealth, which are present in many of the proposed definitions. So first, that its use be intended to provide clinical support for patients, that its use be intended to overcome geographical barriers, that it entail the use of some form of information and communication technology, and that it, most importantly of all, be intended to improve health outcomes for patients. So telepsychiatry is a specific category of telehealth, and often the term is used interchangeably with telemental health care, and it refers to the provision of mental health services remotely through the use of information and communication technology. So given that it generally requires little more than the use of these technologies, such as video conferencing tools, it is one of the fastest growing subsets of telehealth. So the literature notes great demonstrated potential for telehealth or telepsychiatry specifically to improve access to mental health care for several populations for whom access to care has been and continues to be a longstanding issue. And this includes individuals incarcerated in correctional facilities. So why examine or study the implementation of telepsychiatry in correctional facilities? Well, the inequitable and inadequate provision of healthcare, mental health care, is a pressing issue at the global level. For one, the prevalence of mental health conditions or mental health issues is significantly higher in correctional facilities than it is in the general population. And there are a variety of issues that are at the root of this, and they're often systemic in nature, such as structural poverty or institutionalized racism. Inmates are also more likely to have pre-existing mental health conditions than the general population and are often incarcerated rather than provided with appropriate treatment or care. And during incarceration, a variety of aggravating factors such as isolation or exposure to violence often exacerbate these pre-existing issues. So on top of this high prevalence of mental health conditions, there is a lack of access to adequate and optimal mental health care that meets the needs of inmates. And the care that is provided to them often is suboptimal compared to that in the general population and does not adequately meet their needs. So the implementation of telepsychiatry can be seen as an effective way of addressing some of these issues. So an illustration of this is the mandate of the Mental Health Commission of Canada, which is a nonprofit organization that is funded by Health Canada that has identified mental health and the justice system as the criminal justice system as a renewed area of focus. So the Mental Health Commission of Canada has identified 3 guiding principles for mental health reform in correctional facilities. And these are human rights, social justice, and health equity, recovery-oriented principles, and healthcare parity, meaning that the standards of health in correctional facilities be equivalent to those in the general population. So in addition to these guiding principles, the Mental Health Commission of Canada also identified key areas for change in mental health care, the provision of mental health care in correctional facilities. So these are access to early intervention and prevention, continuity of care, quality of mental health services and supports, and reintegration and supports. So these are areas where implementing telepsychiatry can be beneficial, given that not only is there a lack of access, a general lack of access to mental health care in correctional facilities, but the care that is provided, as I mentioned, is often suboptimal and is not provided in a continuous or consistent manner. So before I turn to my discussion of the opportunities and challenges, I would like to provide an overview of the legal norms and legal principles that govern the provision of healthcare and mental health care in correctional facilities. So I will outline the norms at the international level as well as the domestic level. So at the international level, there are a variety of legal instruments that establish standards for the provision of healthcare to incarcerated individuals. So 2 examples are the United Nations Standard Minimum Rules for the treatment of prisoners and the United Nations Basic Principles for the treatment of prisoners. And these exist alongside other general human rights instruments, such as the Universal Declaration of Human Rights and the International Covenant on Social, Economic, and Cultural Rights. So the fundamental principle under international law is that prisoners have the right to the highest attainable level of health care, including mental health care, and that they should benefit from the same standards of health that are available to those in the general community. At the domestic level, I will discuss the legal norms at both the legislative level as well as the common law. So the provision of healthcare in correctional facilities depends on the type of facility. So whether it be a federal penitentiary or a provincial or territorial correctional facility. So under the Criminal Code of Canada, if an individual is sentenced to a term of imprisonment of 2 or more years, they are sentenced to, they serve their sentence in a federal penitentiary. And if they're sentenced to a term of imprisonment of less than 2 years, they will serve out the sentence in a provincial or territorial facility. So at the core of this distinction is the applicability of the Canada Health Act. So while in Canada, the provision of healthcare is largely a matter of provincial or territorial jurisdiction, the Canada Health Act, which is a federal piece of legislation, sets the standards for the federal financial contributions to the provincial and territorial health insurance programs based on a legislatively defined set of criteria. However, individuals in federal penitentiaries are excluded from the Canada Health Act and are not covered by the provincial and territorial health insurance programs. Conversely, inmates in provincial or territorial facilities are subject to the legislative scheme of the Canada Health Act, and the provision of healthcare in these facilities is under the jurisdiction of the provincial and territorial governments. So I'd like to focus a little bit more on the provision of healthcare in federal penitentiaries, given that it is subject to a unique legislative scheme. So rather than being covered under the purview of the Canada Health Act, the provision of healthcare in federal penitentiaries is subject to the legislative scheme of the Corrections and Conditional Release Act, or the CCRA for short. So responsibility for the care and custody of federal inmates under this statute is vested in the federal government agency called the Correctional Service of Canada. So under the CCRA, the Correctional Service of Canada has the obligation to provide inmates with both essential health care and reasonable access to non-essential health care. And in both cases, the care that is provided must conform to professionally accepted standards. And the legislation does include mental health care in its definition of healthcare. However, it does not distinguish what is essential versus non-essential healthcare, nor does it provide any indication or description of what constitutes professionally accepted standards. So instead, the Correctional Service of Canada sets out these standards in a series of guidelines. So this has been noted to make the determination of what is essential versus non-essential very much a context-specific determination, as well as a discretionary determination. And this has been noted to contribute to the lack of standardization and uniformity in the provision of health care and mental health care across facilities, thereby reinforcing existing barriers and inequities. So in addition to the legislative regimes, the common law does impose certain obligations on correctional facilities regarding the provision of healthcare to inmates. So the common law has long recognized the duty of correctional facilities to take care of the health and safety of inmates. In certain cases, courts have elaborated on this general duty, as including an obligation to provide adequate medical care and attention, as well as an obligation to provide appropriate medical care and attention. So it's clear when we look at these legal norms, whether they be at the international level or at the domestic level in legislation or at common law, it's clear that the actual state of mental health care in correctional facilities, as I described more generally earlier, falls short of the prescribed legal standards, and that this failure to meet the legal standards contributes to the continuation of existing mental health care inequities in correctional facilities. So as a legal opportunity, the implementation of telepsychiatry can help correctional facilities meet their obligations and duties towards inmates regarding the provision of health care and mental health care, and as a way for inmates to benefit from the positive health outcomes which they are owed under legal norms and legal principles. So as an opportunity, telepsychiatry can be seen as a way to promote and increase access to mental health care and promote mental health equity, satisfying the legal principles that inmates benefit from the same standards of health as those that are available in the general population. So while it can be seen as a vector for positive mental health outcomes and mental health equity in correctional facilities, there are certain legal challenges in the implementation of telepsychiatry. So for one, the right to health care in Canada is not explicitly enshrined in law. There is no explicit right to health care and perhaps in a general sense in Canadian law. So we see this, for example, in the statutory provisions of the CCRA, where there is this distinction between essential healthcare versus non-essential healthcare, and that the determination between what is essential and non-essential is very much contextual and very much a discretionary determination. So as a sort of general global right, healthcare, the right to healthcare is very much a circumscribed right in the statute and in other sources of Canadian law. Moreover, the right to healthcare is not a constitutional right in Canada. It's not included in the Canadian Charter of Rights and Freedoms. We see in case law that the charter has been litigated to try to be interpreted as providing a right to healthcare. So we see jurisprudence regarding Section 7 on the right to life, liberty, and security of the person, as well as the equality rights under Section 15 of the Charter. However, courts have been reluctant to interpret the Charter as including a positive right to health, though there has been some success in interpreting the Charter through a negative rights lens regarding healthcare, where there are barriers to certain health services for certain individuals or groups, though the success of this type of litigation has been variable. So this general perception of the right to healthcare in Canada through a negative versus positive rights lens can be a significant barrier in arguing for the implementation of telepsychiatry in correctional facilities, despite its many potential benefits and despite the fact that it can meet the legal norms and standards for the provision of mental health care in correctional facilities. So these points of discussion will form the basis for the article that I will be developing in the coming weeks. I would like to thank the CRDP and the Faculty of Law at Université de Montréal for allowing the opportunity to present this work today. I would like to acknowledge the contribution and support of the McGill Research Group on Health and Law and the International Observatory on the Societal Impacts of AI and Digital Technology. So thank you very much for your time and attention today, and I am happy to receive questions or comments by email. Thank you very much.